The Honorable Chief Justice Jeffrey Ma, Professor Song, Professor Gain, distinguished guests, students, ladies and gentlemen, welcome to the CUHK 50th Anniversary Distinguished Lecture. My name is Sabrina Lee, LLB Year 4 student of the Faculty of Law of the Chinese University of Hong Kong. Today, we are greatly honored to invite the Chief Justice Jeffrey Ma, Court of Final Appeal, Hong Kong Special Administrative Region, to deliver a lecture on the university campus. First of all, may I first invite Professor Christopher Gain, Dean of Law of Chinese University of Hong Kong, to deliver a welcoming speech to introduce our speaker. Professor Gain, please.
Chief Justice, Vice-Chancellor, distinguished guests, students, ladies and gentlemen, it's my great pleasure to welcome you here this afternoon to this afternoon's lecture, which is one of a series of distinguished lectures offered as part of the Chinese University of Hong Kong's 50th anniversary celebrations. We are indeed privileged to have as our lecturer on this occasion the Honourable Jeffrey Ma, Chief Justice of the Court of Final Appeal of the Hong Kong Special Administrative Region. Justice Ma studied law in England, graduating with a Bachelor of Laws degree from Birmingham University in 1977. He was called to the English bar in the following year and the Hong Kong bar in 1980. He was subsequently admitted to practice in the state of Victoria in Australia, and then in 1990 was called to the bar of Singapore. He was appointed Queen's Counsel in 1993. Like most young barristers, his early years at the bar comprised both civil and criminal work. Less typically, perhaps, it's understood that he obtained his first brief on the day after he was called, which must be something of a record in the Hong Kong bar. Fairly quickly, he began to concentrate on the civil side, and especially commercial work, including shipping, company law, insurance, and arbitration. However, his later practice also included a number of important constitutional cases, including the so-called right of abode cases in which he appeared for the Hong Kong government. Chief Justice Ma took what he himself has called the usual route to being a judge. He was appointed a recorder in 2000 and was elevated to the Court of First Instance in 2001. The following year, he was appointed to the Court of Appeal, and in 2003 was appointed Chief Judge of the High Court. He was appointed to his current position as Chief Justice of the Court of Final Appeal in 2010. That may be the usual route to becoming a judge, but the speed at which he travelled it and the destination at which he arrived is certainly not usual, even for very distinguished judges. A great deal has been said and written about the importance of a strong and independent judiciary in maintaining the rule of law here in Hong Kong, of course, but elsewhere as well. Rather less has been said about the importance of having a judiciary that is open and visible to the public at large, and one which is prepared to articulate, beyond the confines of the law reports, the fundamental principles and values that guide the courts in their crucial and often controversial task. Confidence in the judiciary and the rule of law does not rest entirely on the fact that the courts have adopted or refused to adopt a given position on a particular issue. Principled decision-making based on respect for the law, of course, is fundamental. But public reflection on the judicial function and the legal and constitutional context within which that function is discharged can, I believe, make an important contribution to public confidence in the legal system as a whole. And that's why judges increasingly must be able and willing to go beyond the limits of their judicial role to explain their judicial function. By his presence here today, the Chief Justice exemplifies that broader, communicative role that senior judges at least should embrace. Let me turn In conclusion to the theme of today's lecture and to the theme of the university's 50th anniversary celebrations, the title of today's lecture is The Essence of Our Society, from a written constitution to reality and into the future 50 years. The motto or theme chosen for the university's 50th anniversary is Embrace Our Culture, Empower Our Future. It's clear that the issues that will be explored in this lecture today fit very well under that Golden Jubilee rubric. An understanding of and respect for the rule of law are of the essence of constitutionalism. That understanding and respect, I believe, are firmly embedded in the culture of contemporary Hong Kong and must remain so. For without that fundamental commitment to upholding the rule of law, then, quite simply, Hong Kong has no future. And that is why today's lecture should be of vital interest to every one of us, and why we look forward eagerly, Chief Justice, to hearing your thoughts on these issues. Thank you.
Thank you, Professor Gain. Without further ado, may I invite the Honorable Chief Justice Geoffrey Ma to deliver his lecture, The Essence of Our Society, from a written constitution to reality and into the future 50 years. Chief Justice, please.
Most important part is the water, actually. Vice-Chancellor, Professor Gain, distinguished guests, students, ladies and gentlemen. It's a great honor to be invited to speak as part of the Chinese University of Hong Kong's 50th anniversary celebrations. 50 years ago, I was 7 years old. No one then gave much of a thought as to what the following 50 years would bring for Hong Kong, least of all what would happen on the 1st of July 1997. In 1963, 1997 was 34 years away. Today, we are 34 years away from 2047, and many people are already asking questions, at least wondering about the next 50 years. By the way, I was talking to my good friend Justice Rivera, who sat there this morning, about what I was doing when I was 7 years old in 1963. I remember I went to my first cinema with my father, and we watched a film, a great film called The Magnificent Seven. I don't know how many of you. It may be meaningless to most of you, but has great meaning to me. In this talk, I focus on the law. I have no expertise in any other area to be able to give any sort of considered view, with a special emphasis on the one document I believe contains the very foundation enabling Hong Kong to function, and that's the Basic Law. The Basic Law is not just a document which conveniently sets out in convenient chapters general principles, fundamental rights and duties, Hong Kong's relationship with the central authorities, our political structure, the economy, education, science, culture, sports, religion, labor, social services, external affairs and other matters. The Basic Law provides a guarantee of rights and liberties, enabling everyone who lives and works in Hong Kong to live a full life, pursue happiness, and have the peace of mind of knowing that there is an entity, the law, before which everyone is equal and on which reliance can safely be placed to protect them and their families. There is a school of thought, much like the Big Mac Index in economics. The Big Mac Index is a rough guide to exchange rate economics and purchasing power differentials. Now, except that this relates to law based on the traffic accident scenario, when one car hits another. In Hong Kong, apart from some possible temporary irritation, everything falls in order and no complication exists. Details are exchanged, the police are contacted, insurance companies then become involved, and everything is sorted out in due course. This is the law in operation. Everything is in order and is done according to law. In some countries, the law is but one factor among others when a traffic accident occurs. One worries about the status of, and therefore the influence wielded by the person with whom you are involved in the accident, and other, what might conveniently be called, extraneous factors. In other words, there is no guarantee of order, predictability, or peace of mind. The law is not only about lawyers and courts. It is partly about them, but most people will not encounter a court or have reason to consult a lawyer in their lives. And yet the law pervades everyone's lives and to a significant extent governs the way we live. It certainly enables a complex community like Hong Kong to operate as a community, providing the foundation for the 7.5 million or so people who live here to be able to do so side by side. When you think about it, this is no easy feat to achieve at all. A population of 7.5 million people means very many points of view, and when one adds to the mix corporate entities, institutions of all kinds, the government, political institutions, religious institutions, or educational institutions, and international connections, the points of view of all who make up a community are multiplied even further. It does not take a person knowledgeable in social sciences to appreciate that society is complex and that it is the law which to a large extent helps keep everything together and helps prevent a breakdown of that society. The law, of course, has two important facets: content and enforcement. The content of the law should be there for all to see, even if at times it can be difficult to understand. The visibility of the law is, of course, a reminder of the two basic functions of the law: certainty and fairness. These two factors make up, for many people, the definition of justice itself. Those who follow ancient history will know that in Babylonia, modern-day Iraq, at about 1750 BC, one figure loomed large, Hammurabi. Such is his importance to law that he appears in the frieze above where the justices sit in the Supreme Court of the United States in Washington, D.C. Ancient inscriptions in cuneiform describe Hammurabi as having put order and righteousness in the land. He did so by having laws put down in writing. The Code of Hammurabi consisted of 21 columns of writing in cuneiform script, extensively setting out 282 laws. The importance of this code lay not so much in the laws themselves, but in that this was the first time in which laws, which were to be universally applied, were made public. The laws dealt with property, family issues. To give you an example of that, a man could not divorce his wife if she fell sick, but was obliged to maintain her, and probate matters. In our eyes, the laws in the code were crude. Doctors, and a doctor, apart from the vice-chancellor, a doctor who negligently performed an operation would have his hands cut off. Now, these laws were not altogether fair either. Slavery was seen very much as a right to be perpetuated and protected. The ancient Romans also had their codes, the great codes of Justinian, another person immortalized in the frieze at the US Supreme Court, and of Theodosius on administrative law. The other important facet of the law is its enforcement. Here, and I will soon develop this theme when I come to deal with the position in Hong Kong, the focus is on the activity of the courts rather than on law enforcement agencies. The enforcement of the law by the courts involves a consideration of the independence of the judiciary, the approach and methodology of the courts, and the vigilance with which judges deal with issues of public importance. All these aspects form what I believe to be the integrity of the law, a term I used earlier this year at the opening of the legal year. The foundation of the integrity of the law is, of course, an independent judiciary. The codes of Hammurabi, Justinian, Theodosius were, of course, quite revolutionary in their statement of legal principles. but there was little evidence of an independent judiciary in Babylonia or in Rome. In the Roman Empire, many judges were tribunes under the direct control of the emperor, and even when what could be called a jury system was introduced, this consisted of panels of senators. Later, jurors were drawn from privileged classes. Varying degrees of bias were inherent and inevitable. Even in the early days of the common law in England, in the mid-12th century, although the king was the fountainhead of justice, reliance was placed on local sheriffs to act as judges. A fair and impartial hearing before these judges could not be guaranteed, as often the sheriffs were open to bribery. It's not necessary to dwell too long on ancient history or medieval history to underline the importance of the independence of the judiciary. More important is to understand what it is and what it means. To many people, it is obvious, but worth repetition. An independent judiciary is one where there is an adherence by judges, allegiance, some may say, to the letter and the spirit of the law and only to the law. While those who come before the courts are important, after all they must be because they are the reason for legal proceedings in the first place, their status and identities are not. And nowhere is this point more apparent than in the treatment of cases involving the government. The phrase, all are equal before the law, is often taken for granted. I think this is good, as long as everyone realizes just what it means and why it is of such pivotal significance. The significance goes back to what I've mentioned earlier as being the role of the law in our community. There is a quote, of which I'm particularly fond, from Dame Sian Elias, the current Chief Justice of New Zealand. She said this: "Law, then, is what convinces. It is the opposite of what is arbitrary." Now, a reminder of the independence of the judiciary in Hong Kong is contained in the judicial oath, required to be taken by every judge on assuming office. That oath requires all judges to act in full accordance with the law, honestly and with integrity, safeguard the law, and administer justice without fear or favor, self-interest or deceit. In these words are encapsulated the obligation to adhere to the integrity of the law. It is a powerful reminder of all that the judiciary stands for. However, it is how judges discharge their responsibilities and honor their oath in reality that matters. I shall briefly discuss this later. Hong Kong is recognized worldwide as a common law legal system and is a respected jurisdiction in the common law world. But first, how did Hong Kong come to have the legal system that it now exists in the first place? The origins of the common law in Hong Kong date back to 1841, when the British arrived in Hong Kong. The reason for the British presence in the Far East at that time was trade. Very soon, trade became the lifeblood of Hong Kong. With increased trade came sophisticated means of finance and, naturally, an international dimension. In 1841, the population of Hong Kong was about 4,000 people, with another 2,000 living on boats. 7 years later, the population had nearly quadrupled. By 1863, this figure in turn quintupled to 125,000 people. In 1925, the population was 725,000. By 1950, the figure was 2.2 million. In 1980, this had become 5 million. At the turn of the century, the figure becomes 6.7 million. Today, as mentioned, the figure is about 7.5 million. In a foreword to a textbook on commercial litigation, I wrote this: "It is, however, not to be forgotten that Hong Kong continues to be one of the most important financial and commercial centers in the world, and much of our community thrives and depends on the maintenance of this status." Trade and finance are complex activities which depend on a series of interconnecting factors: the skill, expertise, and industry of people, geographical advantages, and law. It is again law that provides the essential infrastructure and the basis to enable trade and finance to flourish in an environment that promotes those activities. Laws that govern trading activities include the law merchant, sale of goods legislation, banking legislation, shipping legislation and conventions, regulatory codes in share dealing, company law, and so on. With the growth in trade and finance came, as we have seen, a rapid growth in Hong Kong's population. People came to Hong Kong to seek their fortune. Many people came simply to make a better life for themselves. With the growth in population, there developed a need for a sophisticated legal system to govern the social and political and not just economic aspects of society. Whenever reference is made to the law, it is a reference to the concept of what is commonly referred to as the rule of law. This term sometimes means quite different things to different people. It is used a lot these days, and the term appears daily in the press and other forms of media. For those who are going to the Rugby Sevens tomorrow, you will see this on the TV screens as the Hong Kong government, do you remember the Hong Kong government here? The Hong Kong government, in advertising investment incentives for Hong Kong, will flash as one of the incentives the existence of the rule of law sort of disappearing in a sort of bubble. Now, I often use this term myself, the rule of law. My definition of that term is that the rule of law comprises two connected premises. First, the existence of laws that respect the dignity and rights, whether personal, proprietary, or what are known as human rights and freedoms of the individual. And second, the existence of an independent judiciary to enforce those rights and liberties. This is precisely the same two important facets of the law I've mentioned earlier. Hong Kong, as its history shows, has undergone many changes, even upheavals, but the essence of our society, namely the people and their resilience, their progressive attitude, ambition, social conscience, their international outlook, and the willingness to respect each other and be at peace with one another. This essence has been supported by the law and Hong Kong's legal system. Take the case of corruption. Prior to the setting up of the ICAC in the 1970s, it is no secret that corruption was a problem in Hong Kong, existing in the police force and certain government departments. Yet despite this, at no stage was there any corruption affecting the judiciary, as far as I know. I mention this merely to make the point that the law and the judiciary have, through the many years since 1841, remained institutions providing peace of mind to Hong Kong people. Our system of law, the common law system of law, had and has as its characteristics a respect for the dignity and rights of the individual, an independent and fearless judiciary to enforce these rights, and the ability to instill confidence in our community. And so one comes back to our written constitution, the basic law. The origin of that document was, of course, the resumption of the exercise of sovereignty by the People's Republic of China over Hong Kong on the 1st of July 1997. The promulgation of the basic law on the 4th of April 1990 was preceded by a series of negotiations between the Chinese and British sides, which culminated in a joint declaration, the Sino-British Joint Declaration on the Future of Hong Kong, signed on the 19th of December 1984. One of the main points in the negotiations was to ensure that Hong Kong continued to prosper. Those institutions that had served Hong Kong well in the past and which would continue to make Hong Kong a prosperous and stable society were to be preserved. There was to be no dramatic change in Hong Kong other than, of course, the resumption of the exercise of sovereignty, but a continuation of our way of life and what had hitherto contributed to Hong Kong's success. That is why one sees in the joint declaration a reference to the maintenance of the prosperity and stability of Hong Kong, an account taken of Hong Kong's history and realities, these themes being reproduced in the preamble to the Basic Law. The continuation of these institutions meant that Hong Kong, though an inalienable part of the PRC, would enjoy a high degree of autonomy under the constitutional principle of one country, two systems. So what were those institutions regarded as being so essential for the common good they had to be continued in Hong Kong? I've earlier made reference to the aspect of trade and finance. The Basic Law reflects the importance of these facets in clear terms. Chapter 5 of the Basic Law is headed simply Economy. In this chapter of the Basic Law are contained references to Hong Kong having independent finances, Hong Kong having an independent taxation system, the obligation on the Hong Kong government to provide an appropriate economic and legal environment for the maintenance of the status of Hong Kong as an international and financial center, the obligation on the Hong Kong government to formulate monetary and financial policies, safeguard the free operation of financial business and financial markets, and to regulate and supervise them in accordance with law, the Hong Kong dollar being freely convertible, continuation of markets for foreign exchange, gold, securities, futures, and the like, maintenance of Hong Kong as a free port, principle of free trade, maintenance of Hong Kong's previous system of shipping management, shipping regulation, maintenance of a shipping register, maintenance of Hong Kong as a center for international regional aviation. For me, however, it is those institutions having to do with the law that are significant. The principle of judicial independence, which underpins the whole of the legal establishment, is emphasized in 4 specific articles. Article 2, Hong Kong is to have independent judicial power. Article 19, Hong Kong to be vested with independent judicial power, including that of final adjudication. Article 82, dealing with the power of final adjudication vested in the Court of Final Appeal. And Article 85, the courts of Hong Kong to exercise judicial power independently, free from any interference. The common law is to continue in Hong Kong, including the rules of equity and customary law. The laws previously enforced in Hong Kong would be maintained. National laws, on the other hand, would not be applicable in Hong Kong, save for certain provisions in Annex 3 to the Basic Law, dealing with matters such as the capital, the national flag, national anthem, and so on. The structure of the courts was to be maintained. Accordingly, the judicial system previously practiced in Hong Kong was to be maintained, including the 2-tier system of appeals, the only difference being the establishment of the Court of Final Appeal to replace the Judicial Committee of the Privy Council as the highest appellate tribunal in Hong Kong. The jury system was also to be maintained by Article 86. Judges are to be appointed with regard only to their judicial and professional qualities, and they can be recruited from other common law jurisdictions. There's no nationality requirement for judges apart from the Chief Justice and the Chief Judge of the High Court. The appointment of judges will be made by the Chief Executive in the same way as it was previously made by the Governor in Hong Kong as the representative of the sovereign, but only on the recommendation of an independent commission. We know that as JORC, the Judicial Officers Recommendation Commission. And the independent commission, the JORC, comprises persons, local judges, persons from the legal profession, and eminent persons from other sectors. Your Vice Chancellor is a member of JORC. So far as the legal profession was concerned, on the basis of the system previously operating in Hong Kong, the government of the Hong Kong SAR may make provisions for local lawyers and lawyers from outside Hong Kong to work and practice here. The theme of continuity pervades the Basic Law as a clear manifestation of all those institutions and facets of Hong Kong which were seen to be important to be continued in maintaining Hong Kong's prosperity and stability. I've earlier referred to Article 94 of the Basic Law, in which are contained the words "on the basis of the system previously operating in Hong Kong." This phrase, or similar words, the whole of the basic law is peppered with phrases such as previously practiced, the maintenance of the previous system, and so on. All these phrases all point to the theme of continuity. The courts have consistently held this to be the theme of the basic law. Of course, what perhaps stands out as being especially significant in the basic law is that it identifies constitutionally guaranteed rights and freedoms. These rights and freedoms are set out in Chapter 3 of the Basic Law under the heading Fundamental Rights and Duties of the Residents of the Hong Kong SAR. So these include the right to equality before the law. Article 26 refers to the right to vote and the right to stand for election. Article 27 refers to the freedom of speech, of the press, of publication, freedom of association, of assembly, of procession, of demonstration, and the right and freedom to form trade unions and to strike. Article 28 refers to the freedom of the person and to the principle that no one should be subjected to arbitrary or unlawful arrest, detention, or imprisonment. There are a whole host of articles, 31 referring to the freedom of movement, 32 to the freedom of conscience, freedom of religious belief. 34, Article 34 states that Hong Kong residents shall have the freedom to engage in academic research, literary and artistic creation, and other cultural activities. Article 35 refers to the right of confidential legal advice, access to the courts, and the right to institute legal proceedings in courts against the acts of the executive authorities and their personnel, a direct reference to judicial review. Article 39 provides that the International Covenant on Civil and Political Rights, the ICCPR, should be implemented in Hong Kong. It is in force in Hong Kong under the Bill of Rights Ordinance. That ordinance sets out in 23 articles the Hong Kong Bill of Rights. I should just mention the reference to duties in the title to Chapter 3 of the Basic Law. There really appears to be only one article which can be construed as a duty. Article 42 states, Hong Kong residents and other persons in Hong Kong shall have the obligation to abide by the laws enforced in the Hong Kong Special Administrative Region. There is also a reference to duties in the ICCPR itself. In the preamble to the ICCPR, it is stated, I'm quoting now, realizing that the individual having duties to other individuals and to the community to which he belongs is under a responsibility to strive for the promotion and observance of the rights recognized in the present covenant. The position on paper is, however, but one half of the equation. As important, as I've stated earlier, is how the law operates in practice, and specifically within this, how the law is enforced by the courts. This is where the integrity of the law assumes a critical role. Just how ineffective are the rights and freedoms to which I have just referred? The real test, however, of an effective and respected judiciary is how the courts actually deal with the day-to-day business of adjudicating disputes, how they discharge in practice the constitutional responsibilities, and how they apply that sometimes elusive concept, the public interest. In this context, the type of case that often provides a useful litmus test is the case that arouses public controversy. I'm mainly talking about those cases that engage issues of public law. Public law cases provide perhaps the best examples because very often they involve controversial issues where the court is faced with a number of diametrically opposite views, each of which is passionately held, and all of which may appear to be entirely reasonable. In most other areas of the law, the answer to a legal problem is often fairly clear-cut, even though the discovery of the answer may at times be complex. In the area of public law, however, and in particular cases which involve issues of constitutional importance, very often the interest of the public in general is engaged. Here, the views of the public, and I include the government as well, will be as diverse as the society itself in which the legal dispute before the court originates. When one is dealing with, for example, issues involving the freedom of expression or immigration issues, public controversy is almost certain to arise. The way in which courts deal with such issues, and I'm here not just talking about the actual result of any litigation, is critical. It is critical because the way in which a court approaches such cases, its methodology, and most important of all, its reasoning, will demonstrate whether those principles which provide the foundation of our legal system have been applied. Just what are these principles to which the courts must adhere? Adherence to the law means much more than just adherence to the words of the law. As important, if not more so, one must look to the spirit of the law. A ready example of this is in the way constitutional rights and freedoms are interpreted by the courts. Most constitutions or bills of rights are interpreted by the courts. Most constitutions or Bill of Rights are in similar form, and one will instantly recognize the references in them to the right to life, to equality, freedom of speech, of expression, of political or religious belief, and so on. But it is the way in which such rights and freedoms are construed that provide the essential test. Even if one starts from the standard premise that constitutions are living instruments which are intended to meet changing needs and circumstances, when it comes to fundamental rights and freedoms, they are to be construed purposively, generously, avoiding a literal, technical, narrow, or rigid approach. The spirit of the law is by its very nature an imprecise concept, even at times elusive. Because of its imprecision, it is obviously a flexible concept and can give rise in certain cases to difficulties for the courts. The difficulties arise when the purported exercise of rights and freedoms are taken to their limits and meet head-on the legitimate and reasonable interests or points of views which go in the opposite direction. This type of situation provides a ready example of what I was discussing earlier when I referred to the difficulties faced by the courts when confronted with diametrically opposite, yet on their face, reasonable views. This is where a fine balance needs to be struck, and controversies in the outcome of the case may be unavoidable. Cases dealing with the freedom of speech provide common scenarios in which difficulties of reaching the correct balance are faced by the courts. In 1999, in a case, quite a well-known case, Ng Kong Siu, I think legal scholars will remember, the Hong Kong courts, and ultimately the Court of Final Appeal, were faced with determining the extent of the freedom of expression in the context of flag burning. There existed legislation which criminalized the desecration of both the Hong Kong flag and the national flag. This is the national flag and national emblem ordinance, and the regional flag and regional emblem ordinance. The question for the courts essentially was, did such legislation which criminalized flag burning as a means of political protest or for any other purpose breach the constitutional guarantee of the freedom of expression? The Court of Final Appeal upheld the constitutionality of the legislation, the lower court, the Court of Appeal, having held otherwise. The court was there faced with two diametrically opposed arguments, but each argument in its own way cogent and powerful. The Court of Final Appeal ultimately came to the view that the legislation constituted only a limited restriction on the freedom of expression, whereas the criminal offense protected the unique symbolism of the national and regional flags, which it was felt was important to be preserved, particularly at the early stages of the resumption of the exercise of sovereignty over Hong Kong. Other areas in which courts will sometimes face difficulties in balancing competing interests include challenges made to government decisions where socio-economic factors come into play. In a recent case decided by the Court of Final Appeal, this is Fok Zanhua against the Hospital Authority, consideration was given to the conflict between the constitutional right to equality, in that case in the context of social welfare, and the socio-economic policies of the government. While some leeway will always be accorded to the government where socio-economic policies are involved, there are clear limits. There is no question of any sort of carte blanche being given to the government. Where core values or core rights are affected, the courts will always be vigilant in their protection. These types of cases, these types of decisions made by the courts can, by their very nature, be extremely controversial. I've already made reference to immigration cases. They are controversial in that a sizable proportion of the community will have very strong views one way, and an equally sizable proportion of the population will have just as strong a view the opposite way. Sometimes the vast majority will have strong views against only a tiny minority. What do the courts do in such situations where, whichever way they decide, a sizable number of people will disagree with, if not protest against a result that is reached? The answer is, of course, ultimately quite a simple one in terms of the court's approach. Whether or not a case is a high-profile one, or involves controversial topics, or is just a run-of-the-mill one handled on a daily basis by the courts, the approach is exactly the same, and it is a principled one. The court will simply apply the law to the facts, and the judge or judges will do so, adhering to their judicial oath. No regard will be paid to whether the result will or will not be a popular one, not that this can be gauged in the first place, certainly not whether it will accord with what the majority of the community wishes. Indeed, to have regard to such matters is really quite out of the question. In public law cases, the protection of core values or core rights, as I've earlier mentioned, and the need to adopt a principled approach represents what I hope is a commonly held view of the public interest as far as the courts are concerned. On occasion, the courts will be the last refuge open to a minority in society pitted against the excesses of the majority. This is inevitable given the proper operation and application of the law. And for me, this is what is meant by a principled approach to the discharge of a judge's constitutional role, the adherence to the letter and the spirit of the law and its proper application, protecting those who need protection. It is therefore inevitable that the courts will, from time to time, face criticism, sometimes quite fierce, from sections of the public. Unlike in times long past, it is nowadays common for criticism to be publicly ventilated over the activities of any institution, and the judiciary is not immune from this. Criticism of the decision of the courts is therefore a fact of life, and one must live with it. Hong Kong is no different in this respect, and with the power to strike down legislative acts as being unconstitutional, it is perhaps little wonder that there may be some additional sensitivity in this power given to the Hong Kong courts. And the Hong Kong courts have, on a number of occasions, struck down legislation as being unconstitutional pursuant to the power I've mentioned earlier. Criticisms and discussion of the activities of the courts are indeed healthy to this extent. If such criticism is justified, then improvements can be made or lessons learned. If not, at least people are taking an interest in matters of considerable importance. No doubt, some people will only look to the actual result of cases determined by the courts in order to evaluate the integrity or effectiveness of a legal system. Perhaps that is fine as far as it goes, but in my view, it doesn't go far enough. One ought to be more concerned with fundamentals and matters of principle. For many people, while a decision of the court may be an unpopular one, this is not as important as an assurance that every time a judicial decision is made, the court has acted in accordance with principle, according to the law and proper procedure, and above all, has acted independently. Without this assurance, one can have very little confidence in the integrity of a legal system. In Hong Kong, where we aspire to maintain the common law tradition, and I dare say this will be the same challenge faced in other common law jurisdictions, how is this integrity of the law demonstrated in a tangible way? The answer lies in what is generally acknowledged to be one of the fundamental characteristics of the common law, and that is the reasoned judgment. It is only by looking at the reasoning of the court in any judgment that one can see the processes that have led to the judicial decision that has been made. One can see in considerable detail sometimes the application of the law, of legal principle, and the spirit of the law, and an adherence to those fundamental principles of the common law to which reference has already been made. The integrity of the law is therefore all to see. When one talks these days about transparency, this is the transparency of the law, not just the public and open nature of court proceedings and judgments, but the public display of the very thought processes that make up a court decision. While everyone is free to criticize the decisions of the courts, surely no criticism can be leveled at our courts for a failure to reveal the full extent of the reasons that make up court decisions. It is for this reason, I believe, that the doctrine of precedent forms such an important feature of the common law. The more compelling and cogent the reasons are to justify a result, the more attractive it becomes to follow such reasoning in a later case when a similar situation presents itself. The importance of the reasoned judgment can also be seen by imagining a system in which proper legal reasoning does not exist. Where proper reasoning is lacking, speculation then is fueled as to what may have motivated a legal result. Even judicial independence may be questioned. I would like to think that most people in our community, whether lawyers or not, believe that the legal system which exists in Hong Kong is a good one. I, for myself, believe it is, although it is one that is, like any other legal system, is capable of improvement and advancement. What of the next 50 years? It is perhaps not too early now to begin to think about this. At some stage, important decisions will have to be made. In my present position, I am concerned with Hong Kong's system of law. One of my main responsibilities is for the judiciary to continue to earn the respect and confidence of the community and all who are concerned with Hong Kong. If the judiciary can continue to do what is expected of it, this then is a system that is worth preserving. As the community faces whatever challenges appear in the future, it will want to retain all those institutions that have served the community well in the past and which will do so again in the future. Vice Chancellor, I thank you. I thank you all.
Thank you, Chief Justice, for sharing your words of wisdom. To show our appreciation, may I invite Professor Joseph Song, Vice Chancellor and President of the Chinese University of Hong Kong, to present a souvenir to Chief Justice. May I also invite Professor Gain to join the photo, please. Please join me in giving another round of applause to the Chief Justice, Jeffrey Ma, for sharing your insight with us.